Welcome to our Stowe Talks How-To series. I'm Becka Headley, a paralegal at Stowe Family Law, and in this video we will look at how you apply for and obtain a non-molestation order. To start, if you are in immediate danger, please call the police. Help and support can be accessed from the National Domestic Abuse Helpline on 0808 2000 247 or visit www.nationaldahelpline.org.uk. A non-molestation order is a type of injunction that you can apply for through the family court. These orders are granted to prevent a person from causing you or your children harm. This can include protecting you from someone you're having or have had a relationship with, a family member, or someone you're living or have lived with. Non-molestation orders can protect you or your children from abuse, harassment, or pestering. This includes prohibiting an abuser from using or threatening physical violence and communicating with you. They can prevent someone coming to or near your home, your place of work, or your child's school. A non-molestation order will also prevent the abuser from instructing or encouraging others to do any of these actions. You can apply for a non-molestation order if you are the victim of domestic abuse and the person you wanted to be protected from is someone you're having or have had a relationship with, a family member, or someone you're living or have lived with. You apply for a non-molestation order by making an application to the family court using a form called an FL401. This will be submitted to the court along with evidence in support of your application. There is no court fee for making this application. It is possible to make an emergency application to the court for a non-molestation order if the incident has happened recently, for example within the last week, unless there is a good reason for any delay. It is also possible to make an application to the court and for the court to make an order without the abuser knowing. This would prevent situations where the abuser becomes aware of your application and this aggravates the situation, and they then commit further abuse against you before there is any order in place as protection. To apply for a non-molestation order, you need evidence showing that you have been subjected to abuse or harassment from the other person. A lawyer can help you draft a witness statement in support of your non-molestation order application, outlining the abuse you have been subjected to and any key events that have occurred. Providing evidence of abusive text messages, emails, or social media posts, along with photos of any injuries or damage to your property, will strengthen your case. If you have sought assistance or reported the abuse you are suffering to the police, your GP, or a support worker, a report from them can also be used as evidence to support your case. Once your application is submitted to the court, it will be listed for a hearing to consider whether the order should be granted. Depending upon the seriousness of the threat to you or your children, the order may be made at that first hearing, or there may be up to 3 hearings. Where a non-molestation order is not made at the first hearing, the court may order that the abuser has to comply with undertakings whilst proceedings are ongoing, and then the judge would decide at a hearing whether to make a non-molestation order. Undertakings are promises to the court. Breach of an undertaking is not an arrestable offence. However, the abuser will be in contempt of court, which can result in fines, community service, or even imprisonment. Where you have made an emergency application and an order is granted, there will usually be a further hearing around 2 weeks later to give your abuser the opportunity to tell the court whether they oppose the order being in place. When attending court, if the hearing is in person, you can request special measures to be put in place to protect you from the abuser if they are also in attendance at the hearing. This can include a separate entrance and waiting room or screens in the hearing room. The factors the court considers when deciding whether to grant a non-molestation order are all the circumstances of the situation, and specifically the need to secure the health, safety, and well-being of you and any children. If someone breaches the non-molestation order, this is an arrestable offence. Should your abuser breach the order, you can enforce it by reporting them to the police to start criminal proceedings, or begin civil proceedings by applying to the family court who made the order, for the abuser to be arrested or punished. Within the criminal court, the maximum sentence of breach of a non-molestation order is 5 years imprisonment and a fine. Within the family court, the maximum sentence is 2 years imprisonment, a suspended sentence, or fines. A non-molestation order is usually granted for between 6 to 12 months, although in certain circumstances it could be granted for a longer period. The judge hearing your case will decide the duration of the order, depending on the circumstances of your case and the threat to you or your children. A non-molestation order can also be extended in some circumstances by applying to the family court who initially granted it. Once a non-molestation order is granted and the abuser has been personally served with a copy of the order, it is effective and any breach of the order is a criminal offence. If an order has been made on an emergency basis without putting the abuser on notice, there will be a further hearing around 2 weeks later to give your abuser the opportunity to tell the court whether they oppose the order being in place. At that hearing, the judge will decide whether the order should continue or if it will be disregarded. When the order ends, usually between 6 to 12 months after it is granted, if you feel that continued protection is required, you can make an application to the family court who granted it to extend the order. When deciding whether or not to extend the order, the court will consider all your circumstances and specifically the need to secure the health, safety and well-being of you and any children. The importance of legal advice. It is important to speak to a family lawyer before making any application to the court for a non-molestation order, because you will need to ensure that your circumstances meet the threshold to apply to avoid wasted time and costs. When making an application, your supporting statement and the evidence you provide is absolutely key to the success of your application. It is therefore really important to seek the assistance of a family lawyer who is an expert in this area and can give you the best possible chance of obtaining the protective order. Court hearings can be a daunting task for anyone, especially for domestic abuse victims where the incidents you have suffered are being discussed and your abuser is potentially also present in the hearing room. This can feel like you are in a very vulnerable position, and it is therefore a good idea to instruct a family lawyer, as they or a barrister can be present at the court hearing to represent you and put your case forward on your behalf. It is a great comfort to have another person who is supportive of you being present in the court building, where you may be uncomfortable being in the vicinity of your abuser. If you wish to discuss your options for protecting you or your children from an abusive behaviour that you are suffering from, please do get in touch and we will be happy to have a free initial chat with you and discuss the next steps. For more Stowe Talks, how-to videos and further free resources, visit stowfamilylaw.co.uk/support.